Good afternoon. Welcome to Constitution Day. I'm Professor Schwartz. Few things before we get started. There is a sign-in sheet for students from political science. Last I saw it was over floating around that table. If you are here for the extra credit, if you're a political science student and you're here for the extra credit, make sure that you sign the sheet and you put your section number, your course number and section number after your name. I'm not going to talk very long for one thing because we're only here until 3 o'clock. So, and we're talking about civil liberties. It's kind of a big subject. But we are very honored today to have 3 highly esteemed legal professionals with us from a variety of perspectives. We have a representative from the prosecutor side of the table, so to speak, Gina Cerencion, State's Attorney for Washington County. We have Michaela McNichols, who is a trial attorney in Washington County, and we have Angela Oetting, who is District Public Defender, serving Frederick and Washington County. So the format that we're working with is, if you are here and you're a political science student, you have preference for asking the questions. Please keep your statement of your questions succinct and direct and clear. And if you have someone to whom you want the question addressed, please make that clear as you state your question. Needless to say, be polite and everything. The focus, as I said, is civil liberties. These are not judges. This is not like making rulings on constitutional niceties, but these are people who work with the Constitution every day and have to think about its interpretation. Briefly, civil liberties, for those of you who haven't been studying it this week, civil liberties, sometimes thought of as encompassed in the first 10 amendments to the Constitution, the Bill of Rights. It's confusing. Bill of Rights has to do with civil liberties. Conventionally, we know many of them: the freedom of speech, freedom of religion, but it also protection for people if they are accused of a crime, protection of prisoners. I'm not going to go through them all right now. If you've been taking my class, you know them. So with that, I will, I think if you're okay with me just jumping in with questions? Sure. Yeah, okay. We'll just go in with questions. I think probably the easiest thing is for you to come up here. Well, I will give you the mic, but I would ask for you to identify yourself as you ask your question. That's just standard, public speaking procedure, right? So say who you are and ask your question. So I think we'll have a lot of questions here. So who's first? Yeah.
Hey, good afternoon. How are you, Mike?
Okay.
Good afternoon. My name is Joseph. So I have a question about the Second Amendment and the right to bear. So the Second Amendment guarantees the right to bear arms. But how should this right be balanced with public safety concerns in schools and public spaces? What limits, if any, are constitutionally appropriate?
Who would you like to direct that to?
This is open. I don't really know any of your backgrounds like that, so I don't mind.
You want to take that?
Okay, Joseph.
You can stand up and use that one.
That's okay. Can you hear me? Okay.
It's hard, but I'll listen.
Okay. I'm not as loud as you are, so I should be after all the talking I've been doing my whole life. Actually, the Second Amendment is become a very controversial amendment, as you know. You are in Second Amendment-friendly territory here in Washington County, and the best way to answer that question, I think, is to look at what the guidance we've been given from the United States Supreme Court in several recent decisions, and I can't quote them, and there are several that talk about expanding the Second Amendment to include everybody's individual right to bear arms. Many argue that it was originally limited to those who were going to be within a well-regulated militia. So I think that the Supreme Court currently has taken that further and said that individuals should be able to bear arms for their own safety. They subsequently had a case in which a person had a right, did he have a right to bear arms, or did he have a right to possess firearms when there was a protective order in place, meaning that his either his partner or somebody who was aggrieved by him went to the court, got a protective order, and in Maryland, if you have a protective order lodged against you, you must surrender all your firearms. And so in this particular case, and I can't remember what state was challenging this, but had a similar situation where you cannot have your firearms because you have been deemed to be a threat to this person. The Supreme Court actually wound up agreeing with that and said that there is a public safety exception to your Second Amendment right. Now, I can't tell you the particulars of that, and I apologize because we don't deal with a lot of Second Amendment in the state's attorney's office, but the decision that came out of the Supremes was that there are limits, and public safety is a limit. They've also enacted some, we have in Maryland some statutes that talk about where you can take your concealed carry. And they have talked about, we don't want that to be in a school. We don't want that to be in a church. We don't want that to be, I suspect, a shopping mall. I mean, they're looking at all these places that there are so many people that could be at risk. People are challenging that as well, and I think you continue to see challenges. One of the questions that I was asked at one point was, what if it's a police officer who has their right to carry a firearm anywhere? Or LEOSA for retired police officers. And I was asked, would you prosecute somebody who had his LEOSA and walked into a shopping mall? My answer was no. And the reason for that is this is someone who's very experienced with a firearm, who knows how to draw a firearm, knows when it's appropriate to draw a firearm. I think we're going to see continual questions about the Maryland law, which is restricting where you can carry your firearm, and the citizenry, especially in Western Maryland and parts of the Eastern Shore, that are going to challenge that. I think you're going to see that coming up.
Thank you so much.
And your name is?
I can speak about it if you want. I understand that there are only 18 that always wear on. Why would we raise the limit to 25 or older? And given, like what you touched on, certain mental conditions, like maybe they're safe in something to lock up, maybe they can't have bipolar, because a lot of it is like, socially with us, we want to stop, but our cars want to stop, and everything else. So why not also eliminate the requirement that they are older and have some kind of space to lock up?
Do you want me? I'll take it. I'll take that one since Gina took the first one, but certainly, and I just very quickly, Gina, as you heard, she is the state's attorney for this county, so she is the lead prosecutor for this county, and I am the district public defender, which is a fancy way of saying that I'm the head public defender for Frederick and Washington County. So we work together on a lot of things, but we're also on opposite sides today of the podium, but often of the trial table. And so to address the first question, then go into the second, the Constitution was written now almost, 250 years ago. So things like the internet didn't exist back then. Certainly AK-47s and other types of guns didn't exist back then. So I'm not here in a political capacity at all, and I'd like to keep political statements to a nil since I don't represent the state of Maryland's Public Defender's Office, although I'm one of her deputies. But obviously the Constitution was written when there was a different time. So I think there's always going to have to be limitations on the Constitution and what's written word for word in it. That was over 250 years ago. And as a society, unfortunately, all of us at this table are the legal experts, right? So we go in after the law's passed and argue whether an act was legal or not, right? Whether if you did have a gun, were you violating the law or not? And I would be defending, and Gina would be prosecuting, and Michaela would be defending in her capacity as a private attorney in this county. But there are limitations. And so right now, I believe actually anyone under 21 can be charged as a minor with a handgun. And can that be raised? Absolutely, if that's what the legislature decides to do. So the legislature can always put limits on things, and then those things get challenged in the courts, both civilly and criminally, and the Supreme Court of Maryland will then get to decide those laws, if they're legal or not. But the legislature has the ability to change things and put limitations on things, even constitutionally. And in Maryland, we do have, you can't have protective orders. If you have a mental illness, you're not supposed to, but how does anyone know when you go to apply for a gun if you have a mental illness, right? Like, unless you self-diagnose. There's some obvious exceptions with mental illness. Obviously, if you've had cases, you've been found incompetent in a courtroom, that might come out during a background check, but no one's going to self-diagnose during a background check. So we do put place limitations, but in this arena here, we're usually defending or prosecuting what's already been passed. But personally, I will say, there has to be limitations on the Constitution that was created by people not in this room or any of our immediate ancestors, right? It was created a very long time ago, and things change. So we have to adopt to those changes, and then once the legislature adopts, we then challenge them until, the Supreme Court makes a ruling. You're welcome.
Other question, maybe something other than the Second Amendment? Yeah.
In the Eighth Amendment, it says that excessive punishment shall not be required. Does that mean that excessive punishment can still be used in a certain case?
Michaela, you want?
Go for it, Miguel.
Okay, so since I'm a defense attorney, I'll say no, never. There should be never excessive punishments, but I'll stick to your question and what it's asking us. When it comes to really what a punishment should be, the court looks at different things, okay? And we have what's called in Maryland sentencing guidelines for a reason. The sentencing guidelines consider what type of offender it is. Is it a first time? Is it a minor? Is it a moderate? Is it a major offender? And what happens is that they add points. Okay, so they add points, and usually the state attorney, they run those guidelines. So they will go to certain charges, and you would see what the guidelines are. It's not mandatory upon the court to follow the guidelines, but it's there for a reason, so that across the board, the defense attorneys could have an idea of what the client is looking at, and the clients could have an idea what they're looking at, and the court could consider. But public safety usually always takes a lot of consideration as to what type of crime it is, the victim who may be involved or not, and also the offender as well, and safety to the community. So when you think of a punishment, whether it's excessive or not, you really have to factor in so many considerations. It's not a clear-cut answer. It's nothing that could ever be clear-cut, because each individual, it has to be individualized based upon what is happening, what the type of crime is, and it takes so many things into consideration. Does that help answer your question? Thank you.
My name is Roberto. The Eighth Amendment prohibits cruel and unusual punishment to practices like long-term solitary confinement and life sentences for nonviolent crimes align with this amendment? And at what point does punishment, while not physical, become cruel and unusual?
It's even easier. Thank you. Roberto, one of the issues, or one of the ways that, how do I put this? There are certainly punishments that seem to be excessive. And there are many people within the country that feel that any time someone's in solitary confinement, or if it's a state where the death penalty is still on the books, that is excessive punishment. But over the years, the case law has said, and that's any time a court makes a ruling and it's a controlling court, that these things are not considered excessive based upon the statute of the individual state. So for example, when Maryland had the death penalty, it was very carefully written so that only specific crimes were eligible for it. When Maryland took it off the books, they left us with life without the possibility of parole. Now, the Supreme Court of the United States has said that that is an excessive punishment and cruel and unusual for juveniles. But within that punishment. So what happens is we have an amendment, and that one was probably based on crazy things they did in the common law in England, came here, wanted us to be a little bit more civilized, and then we watched the courts interpret what is cruel and unusual. And certainly things like incarcerating somebody because they owe a debt, they consider to be unreasonable. We have the issue of bail, which people say that's an unreasonable bail. Someone's held without bail for not a public safety offense. They argue about that. But one of the things that you need to remember, I think, with the Bill of Rights is we look at the Constitution. I agree completely with Ms. Oeding. This is an outdated, by centuries document that should have been evolving, that it has a mechanism for evolving, but we read the Constitution and then we have to almost immediately look at what the courts have done, because they interpret it for us, and then we practice within what their interpretation is. So have they said that these things are cruel and unusual? Not as often as you would think. And but there is a movement now about juvenile justice, and we can talk about that for days. But that was one of the last times, and I'll defer to my fellow panelists if there's been something more recent than what they have determined in the Supreme Court regarding death penalty and life without parole for juveniles. Not a whole lot since then, really.
No. Well, I was going to bring up the Second Look Act, which is very relevant right now because it goes into effect October 1st, which I believe is next week or the week after. And so, the law is always changing, and the law doesn't change until something goes up to either the U.S. Supreme Court or the Supreme Court of Maryland. And the legislature this past season established the Second Look Act, which is, it goes to the juvenile justice reform that has been continuing going on recently. And it's giving persons who have a 20-year or more sentence that committed a crime between the ages of 18 and 24, because we know that's when your brain's not fully developed and you do things that a mature you would not have done necessarily. And they can ask now finally for a modification from a judge years after. So there are 500 individuals in the DOC in Maryland who are eligible for a review of their sentence under that act. And that begins October 1st. So our office will be accepting applications and representing people in those hearings to be able to take a second look at their sentences, because we do know, whether you're for, incarceration or not for certain offenses, very long sentences of juveniles or people who are just over the adult age are now considered sometimes cruel and unusual. We have to look at everything. There's sometimes cases where victims' families are coming forth and saying, I actually agree. Like, that person was the same age as my son who was killed, and they were friends, and I realize now he's a different person, whether it's 30 years later or 40, and what they've done on the inside should give them ability to have a second chance on the outside instead of dying in prison. So that's one example of how the legislature and the courts can kind of look at something that was done a long time ago and sort of make amends and change things. Mental health is another one, whether, you were talking about solitary. I mean, some of our clients have severe mental health illness. Remember, presumed innocent until proven guilty. They're held without bail for an offense, but they have mental health illness. And being held without bond on a case that they're innocent until proven guilty can cause all kinds of other issues, right? Like their mental health. A day in jail, I will tell you, having visited many jails and prisons throughout the state, a day there is eye-opening. But imagine, being there a long time with mental health illness. So all of those different things can define cruel and unusual punishment, in which we're reviewing all the time to make sure that we do uphold the constitutional right of having less cruel and unusual punishment.
Yeah. You name Mike?
No, I'm here. Okay. Hi, my name's Ivan Flores. Gosh, that last bit, I had a question relating to that, but I've been wanting to ask this question because it's been something that's been kind of picking at my brain. How I have it phrased though is, to what extent can private companies regulate, restrict, or ban a person's speech on their platform? And then at what basis does the individual have the right to take that company to court? So, for example, where we have companies like Meta that are getting so massive, and we have many people that have reports of being silenced, being banned, being shadow banned. So, how is this evolving in the court?
I'll start, but then I'm going to hand it over to Michaela, I think. I mean, obviously, I'm sure that relates to a lot of recent events, and that's a very political aspect that we won't have time or desire to go into today. But it's interesting, right? Because the private sector employers are different than government employers, right? So I think that matters, right? But there will be challenges to those terminations or suspensions or any sort of consequence that limits First Amendment rights, right? So if you're employed by a private company, you may have different rights than someone who's employed by the government, because private companies are almost all at will, so they can say, well, that could affect morale in the office and fire you. The government, we obviously have a little bit more protection for government employees, so whether it's a public school teacher or a professor or a lawyer who works for a government agency, there's going to be, I assume, there will be some case law that will come out of recent events because of the different employment consequences we've seen with First Amendment rights butting heads with that. So I know it's not the perfect answer to your question, but I think from a lawyer's perspective, there will be some constitutional lawyers and employment lawyers that will be very busy in the future, just like employment lawyers. The number of them are going to be greatly going up. So there's always a need. There's always jokes we have too many lawyers, but in this day and age, I think we don't have enough for everything happening. But you will see it in the courts eventually. And courts are slow, so it's not going to be tomorrow, but hopefully we will see some decisions from the court about those things.
You did well. I'll take
Oh,
it.
okay. I passed, so she's not going to have to go.
Hi, my name is Jacob Stoner. I'm studying journalism. And I kind of have a loaded question, so it's okay if I don't get like a direct answer. But I was just wondering how Donald Trump and his administration can seemingly pass by the Constitution whenever the Constitution was kind of the basis for like the rules and regulations in our country, specifically deporting immigrants without due process.
Oh, you got that? You got it? I don't know if anyone would like my answer, so.
Yeah,
I was thinking maybe the non-government employee might want to answer.
I figured. So Jacob, I decided to be the black lamb here because they are both government employees. They both represent their offices, right? And I'm the only private attorney here. And it's interesting because I am an immigrant, and I will say that openly, and you can hear it through my accent. That's not hidden. But when it comes to the administration right now, I mean, what more could we say at the moment? Because we don't work in those offices, right? Our tools are we work in the courtroom, and we don't represent immigrants. That's not what we do, because we mainly just do criminal defense work. So it's not really a question we could even give you an answer upon. You know, it's the same thing with criminal law. There are some crimes you can't get into a person's mind to really open it up. That's why sometimes they could use, circumstantial things to prove a case and direct things to prove a case, because they could never open up a person's mind to always know why they did certain things. And, it's the same thing when you think about actions. We can't always say why someone does certain things, right?
Go
ahead.
I want to just add, Jacob, that there are a number of challenges, legal challenges, to the practices that you're mentioning. So these are very current court cases that are working their way through.
And I think it's important to remember, and I think that the whole nation has to remember, that we were founded on the principle of separation of powers. We're seeing an incredible number of cases going into the court system because of policies of the Trump administration. And so we are, we're hoping that there's an independent judiciary. We're seeing cases being overturned, wrestling between the different jurisdictions, ultimately landing at the Supreme Court. The Supreme Court has allowed things that I'm a little surprised that they have allowed, but, and I think there are going to be some constitutional rights that are going to come up within the next year. Birthright citizenship, as an example. That it'll be interesting to see if the separation of powers holds, and that if there is overstepping, that the courts intervene. So I hope that answers your question. Yeah.
Just to add real quick, you can go over there while I'm talking. It's very quick. Because I don't want it to look like we're afraid to respond to that question. But as government employees, we are speaking. Gina is speaking for the state's attorney for Washington County. She is the state's attorney. I am speaking on behalf of the public defender's office, right? So what we would answer to that question has political consequences, right? If you want to talk on a personal level, let's grab a cup of coffee and just email me, and we'll do that. But, that's why a lot of it, as someone who works for herself, and I'm very, very proud that Michaela is doing very well for herself in private practice, she has less limitations. So that's why we sort of dodge that question a little bit because of that. So I hope you understand that.
Hi, my name is Jaden. In May of 25, President Donald Trump stated that he and his administration were looking into suspending habeas corpus for undocumented immigrants. Around the same time, Homeland Security Secretary Kristi Noem falsely claimed that the president has full power to deport people. However, the Constitution and Supreme Court affirmed that habeas corpus can only be suspended by Congress. Given this, how might the president attempt to justify or pursue such an action? What impact could it have on the U.S. legal system, and how might it affect your guys' work as law employees?
Well, did you? Okay.
No, I didn't say that.
So any administration is going to do what they want to do, right? And whether we think it's right or not is going to come down to the legal battles. And unfortunately, it goes back to like the last question of we're going to find out when the cases come through, right? I mean, the administration has done some things that obviously there is law that says they can't, and lawyers will have that fight in court. And how it'll affect us personally, the three of us, it probably won't, but there will be tons of lawyers that it will affect, because there will be lots of lawyers that practice in front of the Supreme Court, arguing those constitutional issues all the time. So we're going to see that probably, I would say probably 2 to 5 years from now, right? Legal arguments. Unfortunately, the problem is by then there will have been mass deportations that we can't undo necessarily, right? So it'll be interesting to see how that plays out, and the consequences or sanctions for having potentially broken the law. Those things usually make it up to the Supreme Court, so it also depends on who's on the Supreme Court and how many there are and what the majority is and all that. So it may also, taking politics, no matter what side of the spectrum you're on, not everyone's going to be happy with how it's going to conclude. But unfortunately, it's interesting now to see how it's affected everyone, because everyone has someone that they know that this is affecting in one way or the other.
Other questions? I know there are other questions. No? Faculty, any? Yes. Do I see a hand? Oh.
With the amount of personal information that can be found on cell phones, what should the standard be for the Fourth Amendment? What standard should the Fourth Amendment require for law enforcement to conduct a search? Does a warrant always have to be involved, regardless of the situation?
Yes. Unless consent is given, we are required to secure a warrant to search a cell phone. It's sort of a two-step process. First, we get the cell phone through one warrant, and then we need a second warrant to actually go into it. And the question is there probable cause to believe that there's evidence of a crime? We can't just go through anybody's cell phone. We have to believe that by the standard of probable cause, that we will discover something that would, because phones are used in crimes quite often, as you can imagine, but we do have to meet that threshold before we go into a phone.
I will say, law enforcement may not follow that standard all the time, but that's why we have motions to suppress in courtrooms where a criminal defense attorney and a prosecutor are fighting over that issue, saying they got it legally versus they didn't get it legally, right? So if you're ever in a situation and your phone is just snatched by someone and then it's gone through, you have two issues, right? Was it seized legally, but then was it also searched legally? And you do have to have a search warrant, but it's limited to that purpose of the search warrant. So, if we've had a case where we were challenging the search warrant because it was for a murder case, but the affidavit for the search warrant said it was to try to get details of a drug deal. Well, searching for the other stuff basically went beyond the scope of the search warrant. So we're always challenging those things. So it doesn't always, just because it's illegal doesn't mean it doesn't happen. We then are back here in court challenging it back and forth again. Does that make sense? Okay.
Yeah. Question? Stand up and please give your name.
Hey, my name is Dalton. Thank you guys for being here. So my question is about the First Amendment and freedom of speech. Especially in the aftermath of the Charlie Kirk assassination, many people have various things to say. More specifically, talking about Representative Ilhan Omar's remarks about the assassination. Republicans are discussing the possibility of stripping her of her committee assignments. To what extent are her remarks protected under the First Amendment? Can she be stripped of her committee assignments on the Education Committee as well as the Workforce Committee?
That is really an issue that that's not a criminal issue. So, and unfortunately, all I've done for the past 31 years is criminal law. I would say under the climate right now in Washington, D.C., I suspect that if the House says we want to strip her of those assignments, that they will. But I can't give you a legal basis for that. I don't know that they need one.
Yeah, good point. I just want to reiterate, these are criminal attorneys. So there's the students submitted questions and students who couldn't make it. I have a whole bunch of questions. There's one that I really like that I think is pertinent especially for criminal attorneys. In the Constitution, it says people are granted a speedy trial. However, it always seems like the trials take months to take place. How is this not a constitutional issue?
Okay, I'll start off the answer. So, and we come back again to when the framers of the Constitution made this Constitution, right? I mean, they couldn't foresee how many criminal defendants there would be. I mean, nobody could see that, obviously. That's why there are so many criminal defense attorneys and prosecutors. So you have to really look at the system on a whole. Obviously, there are these speedy trial rights where a trial has to be brought, within the certain amount of time. And I won't go into all the details of what the time periods are, and my colleagues can share them with you. But it really comes into manpower. we have so many judges that are sitting, and think of it this way. Judges have to do criminal cases, they have to do civil cases, they have to deal with custody cases. And most people don't understand the matters that get appealed that actually at the top of the list are custody matters involving little children. And I know it's hard for people to fathom that someone locked up, their interest shouldn't trump a child. But you do have to think of society and who we really protect. And children are really protected because they can't see about themselves. So when people don't understand the judicial system and how it's set up and how it works, it's always easy to say speedy trial rights are always violated. But there are so many things that happen as to what could we do in a courtroom. If we have a trial for 2 weeks, what happened to the other cases that were scheduled at that time? It must get pushed off. If you have a defense attorney representing 15 or 20 or 25 people, we can't be 25 places at the same time. We could only handle one trial. Same with the prosecutor and the state attorney's office. Their state attorneys have multiple matters and they could only do one trial at a time. So it's not by intent that cases are continued. It's just really by design of what we could do.
Can I follow up with that? I'm going to follow up with that just shortly. Sometimes, okay, so going back to the Constitution's really old, right? So speedy trial issues have existed since then, right? But just in the last, 2 decades, really, discovery or evidence in criminal cases has just exploded, right? We have body-worn camera in every case. We may have 5 officers arriving on scene. Each of those officers has body-worn camera. And as a defense attorney, and even with high caseloads, all of our attorneys review that body-worn evidence, right? We have DNA evidence. DNA evidence takes time to process and then time to get to the defense attorney, right, when it's disclosed. And then we have our own experts. Our experts review that DNA or fingerprints or whatever it is to make sure that whatever the state's witnesses did, the lab or the police, did it correctly. And we make sure that that evidence is accurate. And if it's not, we may bring in and subpoena our own witness to come in, that expert, to testify at a trial. So we are always asking for speedy trials, right? Our clients, most of the time, if it's a serious offense, our clients are in the jail awaiting their case. And again, innocent until proven guilty. So they're in jail. On one hand, we really want that trial to go so we can get them out if we can get a not guilty, right? But on the other side, we also have to balance that with, there's a whole lot of evidence the state just gave me, and I need time to be able to review and process that evidence so I know that I'm going to get the best result for my client, right? Or maybe I've reviewed it all, and then I have to have a serious conversation with my client about a plea negotiation, right? So you have to review all that. And so speedy trial, when the Constitution was written or shortly thereafter, you may have been able to prepare a defense in a case very quickly and get a trial done within a matter of weeks. Nowadays, you just could not do that. If you were committing malpractice as the defense attorney in that case because you have to review all evidence. So speedy trial looks differently in Maryland. In the circuit court, you have, everybody considers it the Hicks rule, but it is a state case. And Hicks, in that ruling, the court found that you have a speedy trial right that says 180 days from the time your case got to the circuit court until it's finished. Or tried, I should say. Sentencing is a little different. In district court, you don't have that time frame. You just have the guidelines that judges are told when things should be done. But you have a constitutional right to a speedy trial at all times. We can always argue against that if we think there are delays that were prejudicial. But you also have that 180 days, and oftentimes you will see in Maryland, especially, that being waived by clients of ours if we determine that we need more time to process all that case's evidence before a trial potentially happens. So hopefully that explains that.
My name is Emily. I just had a quick question on the Fourth Amendment when it comes to warrants. Does the panel think that no-knock warrants should be available to police work throughout the country, or do we think that that's not something that we should be doing anymore?
I think it depends
depends on which side of the table you're on.
Well, give it a shot.
My concern always is my police officers and that they're safe, and that was the purpose of the no-knock warrant. And you don't just say, hey, today we're going to do a no-knock warrant. I mean, there is a mechanism for that. That has to be approved, and they have to show that there would be a safety concern if they were to knock and announce their presence. I don't see those very often, though. We have other ways of making sure that our officers are safe. I don't know if the defense has seen them very often.
Well, for 16 years, I practiced in Baltimore City, and then I came out here, and I've been out here for 3 years. So I haven't seen them as much out here, but I've seen a ton of them. And I like to actually disagree a little bit with Gina, although sometimes we often disagree, so that's expected. But I think actually no-knock make it unsafe for everyone, even the police officer, because when you go in somewhere and you just, bum rush into a door, you don't know what's happening on the other side of that door, right? So I think it's actually safer for everyone if we did away with no-knock warrants, both the people on the one side of the door and the law enforcement that are going in. I just think it's I don't know if it has any sort of constitutional basis for my opinion, but I would say that I just think if we're concerned with safety, that it's not the most safest mechanism. Do you want to add anything?
Well, I was going to say what tends to be safe is when we hit houses at like 2 o'clock in the morning. That seems to be a safe way to do it because obviously most people are sleeping.
I'm Warner James, an adjunct English teacher. And I just had a quick question. I know we have a robust enthusiasm for the appeals process, and thank goodness we've got that. I think it's Article 3, the appellate jurisdiction is connected to Article 3. But that having been said, I've always wondered, is there a point where we take it too far? I mean, the current administration really has a history of appealing and appealing and appealing, and it seems as though it takes away from the spirit. I mean, you can appeal forever. So what's the limit? And is the current Supreme Court really interested in being nonpartisan, objective? I think those aren't overly political questions, but I'd love your take on it. Thanks for coming out.
I find, I'm a Republican, and I find that the Supreme Court is a little too political these days. I am very much opposed to the idea of originalism. I don't believe that the Constitution as it was written is the same Constitution that we should use today. There are members of the court that would very strenuously object or disagree with that. I have to believe that the founders created a document that could be changed with the times, but I think there is a political climate in the court now that is dangerous because, again, depending on your politics, that can go the other way. So things that are happening now that the right are happy with, they need to understand that the same thing can happen when the left is in power. So we really need to, I think, rein in the amount of political decision-making that's been happening in the court system. That's my opinion. I do think that the appeals process ends at the top court. So there is a limit in that respect. Now, our top court in Maryland, if it's a constitutional issue, can then petition to be heard at the United States Supreme Court. And we've had some very interesting cases go up to the court and change criminal law, certainly. I think that if everything has to be appealed and everybody is objecting and creating that climate that everything is being appealed, I think you have to step back and see what are we doing, because things, regardless of where your political beliefs are, a lot of controversial things are happening right now. So my belief is, I shouldn't say my belief, is that I think we're seeing so much activity in the courts that is concerning because I'm not articulating this very well. What is happening that we're having to run to court every time a decision has been made? And I think as an attorney, that concerns me. I think it's concerning. I don't know what else to say, really.
I just want to, on the other part of the question about judges and the Supreme Court, there's laws against judges practicing politics, right? So even in Maryland, judges, you won't hear a judge coming out and supporting Gina, for instance, when she runs for re-election next year. You won't see them, opposing Gina either. They're not allowed to give political opinions because they're in their jobs to be fair and impartial for everything. So in Maryland, they're barred from giving political opinions, and most judges I know are afraid to do this type of an event just because they might get a question that's political in nature and they wouldn't be able to respond. So when you are talking about then the Supreme Court being sort of too political or one way or the other, I mean, we've been dealing with that forever because judges are human, right? And we all have biases or biases within us, whether they're implicit or not. And so you tend to lean one way or the other, just as a human being. But they should be taking politics out of everything and deciding it on the law, which is their job. And hopefully, everything that's getting appealed right now, hopefully not everything comes down one way, because it shouldn't, right? Like, they should be looking at every single thing and taking fair and impartial look at it. So we'll see. But the appeals process can be good and bad, right? But that's how we make law and correct bad laws.
Thank you. Stefan, did you have questions from your students?
Yeah, absolutely. I would say I'm Stacey Rankowski. I'm the U.S. History professor here at HCC, and I invited all of my students across all of my different sections to submit questions, and even the ones who couldn't be here today. And I have maybe a little something lighter and frothy. I have a question that might be a little bit more challenging about ideas that you would maybe have for changes to the legal process that would empower your job or help you build confidence. But we can shelf that if we want to do something a little bit lighter and frothier. From one of my History 202 students, Garrett had asked, what made you want to defend or protect the public's civil liberties? Why do you do it?
Oh my. So my answer might take more than 9 minutes, so I'll try to keep the short version. When I grew up in a poor, very modest household in Baltimore County, and I was the first to go to college in my family, and certainly the first to go to law school. I thought I was going to be a prosecutor for my entire life, and then maybe one day a judge. And then I got to law school, and as you all know, I hope, education opens your eyes sometimes. And during my first year of law school, I had an immediate family member who came out as being addicted to drugs, heavy drugs. And I had a cousin who got a prison sentence of 10 years. And those two things during my first year of law school, while I was studying constitutional law and criminal law, really opened my eyes. The summer after first year of law school, I got an internship with our office. I wasn't thrilled because I still wanted to be a prosecutor. But I got an internship with the Office of the Public Defender in Baltimore City. And day one, the attorney I was working for in the felony division gives me a case. It was a drug case, and says, "Give me all the defenses you can find in this case." I was like, "Oh gosh, let me go back to criminal law class." And I come at the end of the day, and he says, "What do you got?" And I said, "I got nothing. This guy's screwed, royally screwed." And the attorney says, "We're going to trial tomorrow. I want you to come watch." And so I went to watch, and it was a drug dealing case. His client was in his 60s, out on the street. And he won that case, but what I took away from it was not that he won the case and that I, as a first-year law student, didn't realize there was any defense in the world, was at the end, his client hugged him, and he gave him a brochure with every AA meeting, NA meeting in Baltimore City. They had this brochure that they could give out. And he gave him this, and he said, "I want to see you at a meeting." And, they shook hands and parted ways. And it was so touching that this man, he had developed this rapport with him and was more than his attorney at that point, right? And he really wanted to see this man change his ways and do better. And I was like, wow, I'm never leaving this office. And I never left the office. Here I am 21 years later, still in the office. But then I realized, yes, my cousin who got the 10-year, like, we need everyone to have a competent attorney who really works with them and believes in them and wants to see better and wants to give them that brochure of meetings to go to and how to change their lives. So even if it's the smallest case where you're just scared to death of that traffic case that carries, 60 days, or a murder case, you got to put in that equal heart into your cases. And that's what made me want to be a public defender for life. And that's why I'm still here.
I'll say the other side. Okay. Well, let me just add a few words before I pass it over to Ms. Serencion. Let me be honest, okay? Defense attorneys, we don't win more than we lose. And let's really put that out there. We don't win more cases than we lose because, for the most part, the state attorney's office is to uphold the law. It's not often, and really not a lot, you're going to find people who did not do it. Okay, and I'm just being honest with you. That's why the law is so important for us, because we look for the loopholes, right? We look for the arguments we could make. But it is satisfying in terms of you fight and you do all you could, because there are always underlying issues, in terms of what's going on and what is beyond the eyes of why people do things. I mean, I didn't know my career would lead me to Washington County. I really took a job. I first started off as a public defender, to be honest, and, it was, for some reason, I got stuck in Washington County. I really did, because I always had a very good relationship with my colleagues on both sides. And it led me to stay here because I realized that Washington County needed more from me than any other county I could have given to, because the people just really need so much. So it's really just a passion, but I would say we don't win more than we lose. But the people we help, and the ones we lose, we help them at the end of the journey for what they need for their families.
I went to law school to be a public defender. It was my goal. I learned very quickly that the person who has the most control over, in my opinion, and certainly I've seen it in practice, over somebody's rights, often is the prosecutor. If there's a bad search, I better be able to see that and say, no, that evidence isn't coming in and a case may be dismissed. It could be that I talk to a police officer who has violated somebody's rights, and I say, you don't even charge that person, so that person is not in the hot seat to begin with. And it was important to me to protect the rights that everybody has. Now, I also have a very long history of working with victims, and that is part of our mission, is to work with victims. Our number one mission is, of course, public safety, but we all, in the office, and we have 18 attorneys right now, and I think to a person, and I could be, hopefully I'm not wrong about this, we are concerned about everybody's rights, because if you don't protect everybody's rights, you're not protecting anybody's rights. One of the ways that we can also affect the lives of the persons that are charged before us is enter into plea agreements where a person does receive treatment, where an issue of addiction has come up, and that's why this person has been committing burglaries or other crimes. And so we, of course, look toward the public safety. We look at the issue of restitution, but we also want to stop this person from continuing to commit crimes. And so we look at what can we do to stop that. And so often we will work with the defense and we will say, okay, well, this is what your client needs. So while we have to exact some sort of punishment, and maybe it's probation and restitution, we also want to equip this person with what they need so that they can be successful. And one of the things that we do at the State's Attorney's Office is we participate in reentry programs. So while I have sent, in 31 years, I've sent a lot of people into incarceration, I'm now working on the back end, which means when somebody is released from custody, they're not just handed $50 and said, say good luck, that we have programs that go into the prison now that help them get a birth certificate, help them get an ID, help them get things that they've never had so that they can go out and get a job. So we're not always the big bad wolf. We do want people to succeed. It's less victimization, but I think it restores people's humanity if they've lost any of that while they are incarcerated. But what my story tells you is you may go to law school thinking you want to do one thing, and then a professor or a situation or a clinic will turn you around, and then you become a career prosecutor, and you go home at the end of the day very happy that the standard of proof is beyond a reasonable doubt, because it's a tough standard. You go at home at the end of the day thinking, well, I did my job, the jury did their job, and even when you lose cases, you go home at the end of the day and say that might have been the right thing. If we didn't make that case, then the right thing happened.
Very good. Thank you. Thank you. And what timing. Wow. 2:59. I want to thank everyone attending here for some marvelous questions, and thank you for the panelists for coming out to our campus, our beautiful campus, and I hope we'll be in touch for future events. And thank you again for, this will be recorded. So.